nominate people for the court and have the Senate or some body of the legislature confirm one way or another. They debated that at great length, just like you're debating this question here about retention elections. And they concluded that they were going to stick with the people, that the judges would be elected by the qualified voters of the state, the Supreme Court. Now think of that. In 1870, when you had no radio, you had no television, you had no automobile, when the people who lived in Knoxville couldn't possibly know who it was that was running from Memphis and vice versa, they put in a system to let the people vote blind, not knowing who the judge was. Couldn't possibly know under those circumstances. But they hewed to the proposition that the people should have the right to select their judges. And they kept that. 1871, Governor Brown passed a law that provided that if somebody died, that there'd be somebody appointed in the meantime, and that judge would hold his office until the next biennial election. It wasn't any retention. He was just an interim judge to hold it to the next biennial election. And when the next biennial election came, he had to run for public office, had to run for judge. And that system prevailed from 1871 until 1971. And then Governor Wilder, whom I greatly respected, Governor Wilder was a friend of mine, and he told me, he said, your papa is the man who got me the vote to make me Speaker of the Senate. He got Bill Peeler from Humphreys County to switch his vote and come vote for me and make him and make me the Speaker of the House. And every time I'd run into him in the corridor and start jumping on him and challenging him about these retention elections, he'd point out to me, if it wasn't for your father, I wouldn't be here. You know I must be right. Your father said I was right. That's the reason I'm the Speaker. Quit talking to me about these retention elections. I'm for them. They're the best way that we should. It's better to select than elect. If he told me that one time in that corridor, he told me many. Now, let me, you're so indulgent to hear me at all, but let me just make a couple of points. These women here know, and us men too, there is no such thing as being a little bit pregnant. We all know that. The same thing's true of the Constitution. It's not a little bit constitutional or a little bit unconstitutional. It's either constitutional or it isn't constitutional. Now, in order to swallow the notion that my good friend Steve Cobb and Alan Ramsar and others, the Attorney General of Tennessee, the members of the Supreme Court, the Tennessee Bar Association. Think of who, I'm just an old guy now, almost 80 years old, and I'm standing here telling you that the Supreme Court's wrong, that the Attorney General's wrong, that the Governor of Tennessee's wrong, when he appointed these two judges, Koch and Anderson, and didn't have an election in 2008, it was absolutely mandated by the Constitution. They called off the election. Ladies and gentlemen, that's one thing you don't do in a democracy, is call off the election. And they called off the election. We have two judges sitting up there today who were appointed contrary to the Constitution. The mandate is that every year, for every 8 years since 1870, you had to have that election. And when 2006 came, they didn't have the election for two members of the Supreme Court who are sitting there today, which circumstance is condoned by the Attorney General, the Tennessee Bar Association, and all the rest. Here's the problem. I'm not your judge. You don't have to, as you well know, don't have to do what I want you to do. But you do have to look in the mirror. And I want to ask any of you who doubt what I say, and there's some on this bench who do, who think that they should vote for the proposition of retention election. I'd just like to hear anybody explain to me how, when the Constitution says it shall be elected by the qualified voters of the state, and that same phrase applies to the sheriff, the county judge, the tax assessor, to the governor, to the legislature, and to every other officer. The word elected means in the context of the Tennessee Constitution the same thing for judge as it does for governor. And yet we have the unhappy circumstance that the trial judges of Tennessee are elected by the people, and the Court of Appeals judges are elected by the retention election, and the Supreme Court is elected by the retention election, and all on the very same words. How can you read the Constitution to say the trial judges shall be elected by the voters of the county and the Supreme Court shall not, with the same words? So the first thing I'm telling you is that if you have an answer to that, I'd like to hear it. The second thing, and I want to conclude here, I'd carry on for too long. Next to the right to vote, is the right to run for public office. I may look like a loser to you. I never got to be governor, but I damn sure tried. And I wouldn't take anything for it. And I hope some of you, Senator Kyle, or you, Senator Jackson, Roy Herron, Lieutenant Governor Ramsey, I hope that some of you will do the same thing. One of my best friends in the world today is Winfield Dunn, the man who beat me for governor of Tennessee. And I told him I was coming down here to speak to you all, and he said, give him all my regards and tell him that I am against retention elections. That comes from the man who beat me for governor, a serious man. So I'm telling you two things in conclusion. Number one, that when you decide on retention elections, you are thumbing your nose at every other person in Tennessee who'd like to run for the Court of Appeals or for the Supreme Court. You are saying that in order to be a judge, you have to be a judge. You are taking away from the people their blessed right to vote and their blessed right to be a candidate. And that blessed right to be a candidate is near and dear to the heart of all people who love democracy. And so I've come here to ask you to give a rebirth to the Constitution, to come back to reality, to realize that there are good arguments about retention elections. But if we're going to have a retention election, Senator Bunch, if we're going to have a retention election, let the people vote for it and vote it in. Give them a chance in a constitutional convention to change the Constitution, but don't change it sometimes without their acquiescence. It belongs to them. If you change it without their acquiescence, it's like stealing from them. It's like reaching in their wallet and taking their money. Don't steal from them their right that's set out in the Constitution. And give our great state the opportunity to have the best lawyers. The truth about it is, and now this in conclusion, Andrew Jackson thought that you didn't need to be a lawyer to be a judge. And he signed that Constitutional Convention along with my ancestor Blunt and others. He signed that Constitution in 1796. And there's no statement in the Constitution that you have to be a lawyer to be a judge. The qualifications are age, residency, and citizenship. And a non-lawyer almost beat a judge, and the Bar Association ran down here to the legislature and threw up their hands, oh my God, a non-lawyer almost beat a judge. We've got to make it so you have to be a lawyer to be a judge. Let me tell you who didn't believe that was Franklin Delano Roosevelt. If he had lived another 90 days, he was going to appoint a non-lawyer named Wendell Willkie to the Supreme Court of the United States. The very Wendell Willkie, who was a Republican nominee for President of the United States against him, they became friends, and he was going to be on the Supreme Court of the United States if Franklin Roosevelt, even though he was a non-lawyer, had the right to put him there. So here's my conclusion. I meant what I said. I think you're good people. I'm proud to be a Tennessean. I think you take your responsibility to uphold your oath of office seriously. And I'm saying to you, if you can't look in the mirror and say that you have the right to pass a retention election law to make it so that nobody can run against you. If you can't pass a retention election law for legislators, if you can't pass one for the governor, if you can't pass one for the sheriff, you can't pass one for the judge. And before you put your initials on the proposition that you can, take a good long look in that mirror and remember that in the end, the greatest thing that comes to an honest man is the opportunity to grade his own papers and do the right thing and be proud of it. I'm here to, if you have an argument against me or you think I'm wrong and you would like for me to try to respond, I'm here. Otherwise, I'll get out of your way and let you go about your business.